The Heathrow Airport appeal is concerned with the planning procedures applicable to the proposal to construct a third runway at Heathrow Airport. The developer who wishes to construct a third runway is Heathrow Airport Ltd. Before any major new infrastructure project of this kind can be constructed, the planning system operates in two stages. First, the government considers national policy at a general level and sets it out in a formal document called a National Policy Statement. This sets the policy framework for the second stage. The second stage involves the infrastructure developer applying for a development consent order, which is to say planning permission, for the development to be carried out. This appeal is concerned with the first stage. After an extensive review, in 2015, the UK government decided that there was a good case for the development of additional airport capacity to be met by the construction of a third runway at Heathrow. The Secretary of State for Transport therefore decided to prepare and carry out public consultation on an airport's national policy statement. The consultation was supported by an environmental report. The Secretary of State formally issued this national policy statement on the 26th of June 2018. In parallel with the development of its airports policy, the government was also developing its policy on environmental issues and climate change. The Climate Change Act 2008 introduced a national target for the reduction of CO2 emissions and also provided for the setting of national carbon budgets. These were periodically revised in the light of the developing science and forecasts. In 2016, the UK ratified the Paris Agreement on climate change. The Paris Agreement sets targets for the reduction of greenhouse gas emissions and also sets targets to try to keep temperature increases resulting from global warming within limits, if possible at 1.5 degrees centigrade above pre-industrial levels. This was a more stringent global target than the 2 degrees centigrade limit, by reference to which the government had previously been working. In March 2016, two government ministers made oral statements about the government's support for the Paris Agreement. They said that the Paris Agreement goal of net zero emissions would in due course be enshrined in UK law. The issue was not whether this would be done, but how it would be done. An important set of questions would have to be answered before the necessary legislation could be introduced. Before the airport's national policy statement was issued by the Secretary of State for Transport, the Committee on Climate Change gave his department advice about the impact of the Paris Agreement on existing national carbon targets under the Climate Change Act. The committee advised that the government should keep those targets under review, but as things stood, they did not need to be changed immediately. The relevant forecasts and scientific understanding were developing, and it was possible that adherence to the existing targets under the Act would prove to be compatible with the Paris Agreement targets. If it later transpired that the targets needed to be made more stringent to comply with the Paris Agreement, they could be tightened up when that became clear. The Secretary of State took this advice into account in drafting the airport's national policy statement. It expressly stated that any application for planning permission for a third runway in the future would have to be assessed against the future up-to-date carbon targets applicable at that time. Friends of the Earth and Plan B Earth launched legal proceedings seeking a declaration from the High Court that the airport's national policy statement was unlawful and of no effect. The High Court dismissed their challenge, but they were successful in the Court of Appeal on 4 grounds. The government decided not to appeal, but Heathrow Airport Ltd has appealed to this court, as it is entitled to do. It disputes the 4 grounds on which the Court of Appeal found for the respondents, and seeks to restore the judgment of the High Court. At the heart of the 4 grounds is the contention of Friends of the Earth and Plan B Earth that the Secretary of State did not properly bring the Paris Agreement into account when deciding to issue the airport's national policy statement. This is disputed by the appellant. The Supreme Court unanimously allows the appeal. It finds that the Secretary of State did take the Paris Agreement into account. He was not legally required to give it more weight than he decided was appropriate, in line with the advice of the Committee on Climate Change. The national policy statement is not affected by any unlawfulness and is valid. The first issue in the appeal is whether the oral statements by government ministers supportive of the Paris Agreement fall within the phrase government policy, as that is used in Section 5, subsection 8 of the Planning Act 2008. Under Section 5, the Secretary of State was required to give reasons in the National Policy Statement to explain the policy, and in doing so was required to explain how it takes account of government policy relating to climate change. The reasons he gave referred to the targets in the Climate Change Act, but did not mention the Paris Agreement separately. This issue depends on the interpretation of the words government policy as used in Section 5(8). The primary meaning of government policy in this context is a formal written statement of government policy in a document such as a white paper. At the very least, what is required is a statement of policy which is clear, unambiguous, and devoid of relevant qualification. Neither the Paris Agreement itself nor the oral statements by government ministers qualify as government policy according to this test. Therefore, the Secretary of State was under no obligation to discuss the Paris Agreement separately in the reasons in the National Policy Statement. In the course of its submissions on this issue, Plan B Earth also drew attention to the fact that the Paris Agreement target to restrict global warming to 1.5 degrees centigrade above pre-industrial levels is more stringent than the 2 degrees centigrade target used previously by the government. However, as the court observes, this feature of the case does not lend any support at all to the objector's case based on Section 5(8). The second and third issues in the appeal concern Section 10 of the Planning Act. Under that provision, in issuing the National Policy Statement, the Secretary of State was required to have regard to the desirability of mitigating and adapting to climate change. The issue is whether the Secretary of State took the Paris Agreement into account. The Court of Appeal appears to have thought that he did not take it into account at all, but with respect to them, that is not correct as a matter of fact. The High Court reviewed the facts with care and correctly found that the Secretary of State did take the Paris Agreement into account. The Secretary of State had regard to the advice of the Committee on Climate Change that the existing carbon targets under the Climate Change Act sufficiently took account of the Paris Agreement at that time. The Secretary of State also drew up the policy statement to ensure that any changes in emissions targets in the future would have to be taken into account at the stage of an application for planning permission, again in line with the advice of the Committee on Climate Change in relation to the Paris Agreement. There was no legal obligation on the Secretary of State to do more than this. The fourth issue on the appeal is concerned with the EU's Strategic Environmental Assessment Directive. Under the directive, an environmental assessment must be carried out for a major infrastructure project. As part of that assessment, public consultation is required on the basis of an environmental report prepared by the government to explain the options. The question is whether the environmental report prepared by the Secretary of State was adequate for this purpose. It referred in general terms to the UK's international obligations with respect to climate change and to their national carbon targets, both of which covered the UK's obligations under the Paris Agreement. But it did not refer separately and distinctly to the Paris Agreement. The objectors accept that the Secretary of State has a wide measure of discretion in drawing up an environmental report as a basis for consultation. He is entitled to focus the report on the principal issues arising. This court holds that the Secretary of State acted rationally and in compliance with his legal obligations in preparing the environmental report. He referred to the UK's international and national climate change obligations and did not have to go into more detail. Of course, the fact that something is not referred to in an environmental report does not prevent the public from raising it in the consultation on that report. That is what happened in this case. The Paris Agreement is well known. Several objectors referred to it in their consultation responses. Nothing in the environmental report misled them or prevented them from making representations based on the Paris Agreement. Those representations were taken into account by the Secretary of State in his environmental assessment for the National Policy Statement. This feature of the case again shows that the Secretary of State took the Paris Agreement into account when he decided to issue the policy statement. He did not ignore it. For these reasons, the court unanimously concludes that the appeal should be allowed. The airport's national policy statement is lawful. The declaration made by the Court of Appeal stating that it is unlawful will be set aside.